Hello and welcome to Legally Speaking with me, Tarun Nangia. It's been about 18 months now, close to 18 months since March 2020, that courts overnight shifted to the digital mode. They use the digital medium for hearing cases. Of course, the pace hasn't been what was there in when physical hearings were around. But now I think we are coming back to normalcy as far as COVID is concerned. The cases have been piling up. In fact, before I planned this show, I spoke to some people and they were very worried because they said that crores of investment payments, so many things are stuck because cases are not being heard at the pace that that is now possible. So I thought, why not invite a very eminent panel to discuss that for Make in India, for investments to come in, for contractual disputes to be solved, to ensure that people are paid salaries on time, because if your money is stuck in a dispute, many times people are not able to pay salaries to their employees. To also ensure that banks get their money, because this shouldn't go be an NPA, because if your money is stuck, you're not able to pay your installment. If companies can't pay installments, then it becomes a non-performing asset for the banks. So I think courts are central to this cycle. And I remember a very eminent economist telling me once that a society's growth depends on how fast it solves the contractual disputes. And in India, the dominant method is courts. Of course, there is arbitration, but I think courts still do a lot in India. And that is why we all need the support of the courts to get this country going back again on the path of progress. And also, of course, a lot of lawyers depend on courts for cases. So it's also an issue for lawyers' employment. That is one thing. So I'll introduce you to my panel today. I have with me Justice Arjun Kumar Sikri, eminent jurist. Sir has served as judge of the Supreme Court of India. I have with me Senior Advocate Vivek Tankha. He has served as the Advocate General of the state of Madhya Pradesh. He's a sitting member of Parliament, so he can give us both sides: the commercial side, the constitutional side, the criminal side, the society angle also of cases. That would be something that I would request him to share with us today. I have with me Senior Advocate Parag Tripathi. Thank you so much for making time and joining us today. I would like to I'd like to welcome Mr. Ryan Karanjawala, Managing Partner of Karanjawala and Company, one of India's leading litigation law firms. Senior Advocate Mohit Mathur joins us, and he's one person, but he's representing about 30,000 odd lawyers. So he's the president of Delhi High Court Bar Association, so he's one in many voices. So I think if you want to know what these 30,000 lawyers thinks, we should hear him today. I would like to then thank each one of you, Justice Sikri, Mr. Tankha, Mr. Parag Tripathi, Mr. Karanjawala, Mr. Mohit Mathur. Without all your support, this show wouldn't have been possible. So let us start with an opening comment. May I request Justice Sikri to open the discussion and lay the ground for this issue?
Yeah, Tarun, I think your initial comments which you have given are really apt and very correct. COVID has great impact insofar as the functioning of the courts or the judicial functioning is concerned. It came to standstill totally when in March 2020 lockdown was declared, and over a period of time, as you rightly said, that we switched over to technology, because I feel that doing judicial work is also a service, and it is an essential service. Like so many services which were still on even during lockdown or COVID, without which you could not do, like health services or supply of foods, etc., and other essential items. This judicial service or the judicial function also falls in that category. But then, if I supplement to what you had said, we had, before this COVID in India, for last number of years, we had about 35 million cases in Indian courts. Out of these 30 millions in district courts, about 4 to 5 millions in the high courts and maybe 50-60,000 cases in the Supreme Court. This figure has gone to almost 44-45 millions.
44 million.
Yes, it has gone to more than 40 millions, I know, but it should be close to 44-45 millions. So therefore, this much of backlog is added. And it was, of course, technology has helped us. And because of this, the essential service was not totally snapped. But at the same time, although the courts were working on virtual mode, but at the same time, as I would say that the courts were not functioning with full strength for various reasons, and it need not be discussed here. Maybe the technology was used, but that technology was not upgraded to that extent. In various courts, it took some time, and COVID had its effects when this. Particularly the second wave, we know when so much people were affected thereby, and as a now I'm doing arbitration, so as arbitrator I know from almost first week of April till third week of fourth week of May, almost every hearing was cancelled because one or the other party was either suffering from COVID. It may be party, it may be lawyers, or it may be sometimes some arbitrator, or offices are closed, or for whatever reason. So therefore, even when the courts could function by virtual mode, but courts were not able to function with full strength. So most of the courts were taking urgent matters only. And because of these reasons, many of these cases could not be taken up in all categories, as you said, whether it is civil case or is a criminal case or whether it is these are commercial cases. And when it comes to commercial matters, again, you are right that your first initial comments was that COVID has affected the business and economy to great extent. Everybody knows. And then when the cases are pending and we are not able to decide those cases, commercial cases, etc. And when we talk in terms of ease of doing business or the enforcement of the contracts, and the cases are delayed because of this reason, they may have effect on the FDI. And this is foreign direct investment, the outsiders may not be. But I tell you, here we have to just, it may not be a straight answer whether the enforcement of the contracts or the awards, etc., if it takes time, like it takes time in India, whether it has any effect on FDI. I'm just giving an example, and it's a food for thought I'm giving to you. Like, take, for example, China.
Yes.
When China also ushered into globalization and liberalization, it started 8 years before us. We started in 1991, so they started even 8 years before us. Where was any judicial system in China? They were hardly. And if some dispute arises, nobody was able to resolve. And I know, at that time we were lawyers and we used to attend so many these functions, etc., international seminars, webinars, and even I'm talking of early 2000 also. The investor who has invested there, if some dispute arises, or that investor has invested, that company goes bust, etc., they were prepared that we are not going to get anything now. But still, China had been getting maximum FDI. So therefore, what I'm trying to say is that merely enforcement of the contract or the efficiency in judiciary and to decide the case earlier may not be the sole ground for this. Right. There may be other factors which may still persuade the investor to still come, which happened in China. And in spite of, yes, we have, the reforms which may be necessary here is at two levels when we talk of ease of doing business or contract enforcement in the ranking with insofar as statutory reforms in the first place, which India has done in last number of years, right from 1996 Arbitration Conciliation Act, amendments in all IPR laws, Trademark Act, Copyright Act, etc., and Patent Acts. The amendments are new Trademark Act was given, and then amendments in the Arbitration and Conciliation Act. So all this, and IBC, which was again a very path-breaking legislation. So it has improved the ranking, and because of that, atmosphere has been good. But yeah, at the same, then we can talk it later in further detail. But having said so, it is necessary at the end of the day, the commercial world wants the cases to be decided expeditiously. There is
Yes.
no denial of that fact.
Yes.
And how it is to be done, we are discussing that, and on that I will.
Point very well taken. 2 3 points you made. I go to Mr. Vivek Tankha. Mr. Tankha, you had ensured that monies were given to a lot of bar associations in Madhya Pradesh, where a lot of lawyers took those monies because, of course, there were no cases and they had to run their families. So you also acquainted us with the other angle about 4 5 months ago. So there is one, on the one hand, needs of the business and industry. There is, on the other hand, which you told me, lawyers earn a living out of this profession. So how would you balance all of this? What the courts need to do in your view?
Thank you. Let me tell you that it's a very serious situation. No, it's not only in Madhya Pradesh, but also Delhi. The number of calls, I mean, you can ask the president of the bar, Mohit is here, that, Tarun, how many people are facing depravity? So many AORs have called me that my children are studying in schools and I can't give fee. I mean, it's pathetic what's happened. And it's because of COVID, of course. But more than that, I think we still haven't learned our lessons. Who stopped you from making appointments during COVID? Your tribunals are not staffed. You see, it's NCLT, you see armed forces. I'm not even talking of high courts and Supreme Court. Of course, we are understaffed. But forget high court, Supreme Court, even your lower courts, your tribunals, pathetic. There are no benches in NCLT now, virtually, or NCLT. People are shuttling from court to court, I mean, hearing cases. So more than that, what is happening today is that there is a complete impasse. Today, fortunately or unfortunately, I had put a motion in Parliament. It could be taken up because of the din. I said, sir, the VC system barring high courts like Delhi High Court or Supreme Court, in most high court, it is miserable. You're not connected beforehand. You're waiting for your turn. Only when the turn comes that you get connected. You don't even know when you're going to be connected.
Yes.
You're taken by surprise. It's not an open court system. No, it's 2 years. We haven't done that. I know clients. I have a Malaysian client whose contracts were terminated sometime in 2003-4. They were in dispute from 2006. The dispute still pending in apex court. Government has lost, appealed 32 times from lower court to Supreme Court, many times over, and lost all 32 times. And Prime Minister of Malaysia, the ambassador, the foreign minister have written letters to Government of India. They're even seeking to invoke the bilateral treaty. I said, these are not things. These are not things because of COVID. COVID has only made it worse.
Oh.
So what we have to do, and I'm going to request the Bar Council one day, I've been talking to Manan Mishra on this point also, I said there is a time when all bar associations, all stakeholders have to come together. We have to open up courts. We can't be very conservative. If you are too conservative, it will take too long. You'll have to be a little bold and open up courts. Because today, COVID is virtually, we can say it's quite under control. I won't say it's finished. We don't know if the third wave will come or not come. But are we prepared to ensure that our fraternity or the country gets famished? I mean, there will be no decisions. Whether it's a family court or a commercial court or a constitutional question, look what's happening in Kashmir. They're waiting for their judgment hearing. So it's not just COVID and commercial courts. The whole country is in a state of impasse. You have to break this impasse. You have to come out, and you can't be conservative about it, because if secretariats have begun, people have started going to the markets, your cinemas have begun. Maybe you do it with care and caution. Maybe you do it in a limited way. But things have to start. That's what I want to say.
Thank you for coming out very strongly, and you acquainted us with many other areas. Of course, as a parliamentarian, we get to know those sides of the society also, which you now acquainted with us. I hope the courts will now take cognizance of the opinions and the words that you just put out in front of the people of India. I'll go to Mr. Karanjawala. Mr. Karanjawala, I mean, Justice Sikri has spoken, Mr. Tankha has spoken. How would you take this discussion forward?
So, first of all, I agree with both Justice Sikri and Vivek Tanka, uh, who pointed out one thing. Justice Sikri pointed out that the courts opened from vacation, and the first thing that we saw was a huge amount of pending areas. Simultaneously, along with that, what we see is a huge number of judges' vacancies remaining unfulfilled.
Yes.
Vivek rightly pointed out that it's not only in the high courts and the district courts, but also even in the tribunals. Now, with these two parallel things functioning, the courts have to find a way to break the logjam and go forward. Now, there are two suggestions I have. One is I feel that the court should adopt what I call a light switch approach. So, the minute you see, as it is in Delhi today, that the numbers are really small or the numbers have reduced, just put the light switch on and go full throttle. Go back to full-fledged hearings like you used to pre-COVID, so that at least some momentum can be picked up. Some of the areas can be looked into. The other thing I had suggested in one of your programs earlier was take the example of people like Justice Kathawala in Bombay, Justice Jasmeet Singh over here, and you find that on some days they sit way beyond their normal working hours,
Yes.
only in order to
Finish the board.
eradicate as much backlog as is possible.
Yes.
Maybe the time has come when the courts have to say to themselves, well, look, whatever has happened, we have lost ground in the last 18 months. Areas have mounted in an inordinate way. We
Yes.
need to take extra measures in order to reduce these areas. And maybe one of the things which I had suggested earlier was that voluntarily, in an institutionalized way, all the courts, the high courts, the Supreme Court, start working about half an hour extra every day.
Yes.
The advantage of that is that half an hour extra every day means one half working day extra in a full week. These are the things you'll have to look at if you want to break the logjam, because otherwise you're going to have a lot of problems.
Point
And even in the places where the COVID is at a bit of a rise and you want to still stay in the virtual mode, at least then have the full board put in court and try to dispose as much of it as possible. I think that's the only way to go forward.
Point well taken. And in a sense, you concurred with your panelists and said that
Absolutely.
this half an hour extra should happen. I'll go to Mr. Parag Tripathi. Sir, if you can share with us also what you think about what your co-panelists have said, and of course your own opinion taking the discussion forward.
I think Justice Sikri made a very, very interesting and a point which we often overlook, that sometimes we overemphasize the role of courts in ease of doing business, because he points out that in China, without a court system, they were able to get in FDIs. I find that a very interesting view, and I think I never looked at it in that context. It brings a lot of realism back into our inflated egos of a lawyer. But I think that's a point very well taken. Vivek and Ryan pointed out the urgent need to move on. Now, here, let's look at, we all know who the stakeholders of the system are. At one end, you have the judges, the judicial officers, and of course, the court staff. That is the staff of the judge, the court master, etc. Then you have the lawyer, the paralegals, the interns, and the clients. That's one second lump. And the third lump is the registry. Now, we know that when we were having the virtual system or a hybrid system, which was going on before the terrible second wave hit us all, the only stakeholders who did not have an option whether to go virtual or not were the judicial officers, that is the judges and the judicial officers, and the registry. I think that's not fair. However, at the same time, there are lots, and Mohit had pointed out in one of the earlier programs of yours, that there are lots and lots of lawyers who are not having the wherewithal to utilize technology, because technology comes with a price and an expertise both. What I think is, and maybe that's an idea worth giving it a thought, give an option to the judges also to go virtual or not, but keep the courtrooms open. So if you keep the courtrooms open, judges have a right to be on the virtual mode. The other party or the parties have a right to be on a virtual mode. Such of the lawyers who feel that they don't have the wherewithal to be able to access technology can go to the courtroom and access technology from there. The advantage there would be twofold. One, we have in the last wave, we know that we have lost some very, very able judicial officers. We have lost judges, including a very distinguished judge of the Supreme Court. Therefore, exposing people is not a good idea at all. At the same time, giving access is also very important. So if you keep the courtrooms open, such of the lawyers who want to come to court, who feel that they will have a better access to technology in court, can go for a hearing with one caveat, that it is left to the discretion of the court, and the court can exercise that discretion and inform in advance that this should be a virtual court at least for this week. Secondly, only those people should be permitted really in the court who are double vaccinated. Maybe you can limit it to single vaccination, but I think double vaccination is important, because Ryan made a very good point. I like his analogy of the switch on, switch off. But the problem is that COVID is such a sneaky and nasty bugger that by the time you switch off the light, the damage sometimes is done. And that is the problem. So therefore, if you can have a system of only those who will come in who have a double vaccination, that will surely help and result in confidence building. Secondly, we can also have an hourly shift, or at least the list divided on pre-lunch and post-lunch basis. Even though you have a virtual court, courtrooms are open, lawyers can come in with clients. At the first instance, till the third wave either happens or hopefully doesn't happen, we can give it 3 months. Let us have no clients in the courtroom, in the court complex. They can take their access from the internet. Therefore, we can have hourly. The NGT used to have that. The National Green Tribunal used to have that. They used to have an hourly list. So you can have a half-day list. But I think, really speaking, the real problem, which has of course come to the forefront and has become worse because of COVID, are our endemic problems with our reforms of our system. And there are 3 big problems here. One is there are vacancies, as Vivek rightly pointed out, in the higher judiciary, in the district courts, in the tribunals. I was arguing in APTEL the other day, and by 31st October, APTEL will have just 1 member with no chairman. And all these retirements are known in advance, and there's so much which has been written about it. So one has to go ahead. I had a thought, which is of course counterintuitive and open to serious criticism, but my thought was, there's a judgment of the Supreme Court in Lok Prahari saying that you can have ad hoc judges. What I feel is, just like as in the case of Vishakha, where Supreme Court stepped in, Supreme Court should consider stepping in and saying that judges, members of tribunal, etc., will only retire, will only be released, if I may use that expression, once the incumbent comes in. And then you give them a 3-month period. So that it's not that you tell me today and I have to go tomorrow, because everybody knows, take Delhi High Court with 60.
This has happened in few cases where the Supreme Court has said that I remember NCDRC, Justice D.K. Jain's tenure in spite of that was extended, and 1 or 2 members also of NCDRC and some other tribunals also.
That's a very good point.
IPAB. And sir, the advantage there is, take Delhi High Court. We have 62 sanction strength, and we are having judges retiring. So it is clear that there is no, I'm not saying wait for the 62nd appointment, but surely don't allow it to fall below what it is today. It's 30. So let the judges continue. When new judges come, within 3 months, the senior most of the judge who has continued beyond 62 in the case of the High Court will say that now I get my freedom and I move on. That will be very important.
Point very well taken. I would want to take this ahead on one of my other shows. This point of not releasing until you point another one. But we are short on time now. I'll go now to Senior Advocate Mohit Mathur. Mr. Mathur, you are the repository of the trust of 30,000 advocates who practice in Delhi, maybe more. So in a sense, they place their trust in you to raise their voice. And what would be those words today from your end? What are you going to voice today on the show?
Tarun, I am also accused by a section of people that I am going by the populist views, but they forget that it's the majoritarianism which works. So I have to go by what the majority wants. Before I say anything, I must, in fact, Mr. Karanjawala had on the last occasion also in one of the shows talked of this half-hour extra. In fact, I took this suggestion and thought that it's in fact a very indeed a good and a novel suggestion, only to be told by our own High Court registry staff that in Delhi High Court, because of the already backlog situation and now the courts have allowed from the extremely urgent to even the last year's cases to be listed, 2020 cases to be listed, that out of the 24 benches that we had, about 16 to 17 of them are regularly sitting for half hour to 40 minutes on a normal basis to finish their daily board. So I think what Mr. Karanjawala had in his mind is also weighing in the minds of at least our High Court judges, and I must thank them for that, because I thought I would give them a suggestion, but probably they were already doing it. Another thing which came from Mr. Tripathi was about the wherewithal of the people, the lawyers having as wherewithal of the technology. And he suggested opening of the courtrooms for that, for the VC hearings. I also want to inform everyone, at least in the Delhi High Court, we have 4 courtrooms which are dedicated to VC hearings for enabling those lawyers or litigants who are to fight their own cases, who do not have their own capabilities to run it. So they have a full VC system running in those 4 courtrooms, which are dedicated for this very purpose. Besides that, the Bar Association, in conjunction with the High Court IT staff, we have what we have as Vimarsh rooms, which are consultation rooms, which we have made for our members, because these days there is no court activity going on. So those are 6 rooms there. Those 6 rooms also, we have Wi-Fi and computer already installed, which was basically also for the local commissions to be recorded and evidence to be recorded. So those are also made available. But sir, having said that, I find that keeping everything working on technology is neither a system which is sustainable, nor sir, it was envisioned. Because reason is this technology was thrust upon everyone suddenly. And the entire system is not placed for that. What we forget is that in a high court where things are being digitized for a very long time, still Delhi High Court also only last 5-year files are completely digitized to be taken up on virtual hearings. So when you don't have files which are digitized, how can the poor judge look into those paper documents, and where will he look for it? Somebody will have to bring it to him. And the second wave, in fact, impacted a lot of court staff, which has actually sent shivers. So I would not, in fact, agree with Mr. Karanjawala, and I would feel probably similar to what Mr. Tripathi said. This light switch approach may not function, because what I was accused of on the last occasion was that I was pushing for physical hearings, and this second wave came. Fortunately, people have not blamed me individually for it, but otherwise, there is enough flack which has come that I have pushed for the physical. But why I pushed for physical hearing, and I would still say that is the norm. You may do it a little later. You may see the scenario, you may see the situation, or you may review it, may not be on a daily basis, but maybe on a bi-weekly basis, that if in the next 3-4 days, 5 days, you find that there is a slowing down, a phased manner. And that's why Delhi High Court, the notification, last notification of 20th July was that from 16th of August, we are looking at a partial resumption in a manner which started last year. See, the difficulty which people face today is there is a huge lot which has only physical files and limited number of cases.
Yes.
Why we keep on forgetting is that the panel before you may be having enough work. People who are otherwise appearing before the VC hearings have sufficient work otherwise also. It's not that ordinary, the mango lawyers, the arm lawyers are not the ones who are coming in VC hearings so often.
Yes.
Those people are actually looking for those A versus B cases. And those A versus B cases are actually now being relegated into the archives because they're not being picked up. So first thing is that this back to the courts can only be either you open everything on the VC so that everyone gets an opportunity.
That's my takeaway point from you today. Open everything on the VC. And you made another good point. Every 3 or 4 days, bi-weekly review, if you can open physically, and go ahead if you can.
Yes. So the difficulty which one needs to, how it is to be solved is that you open everything on VC, and as and when or whichever jurisdiction you feel requires physical hearings, you allow those. Then that will also leave only selective cases for the physical hearings. And obviously, see, the commercial cases and people who are equipped in arbitration cases, other jurisdictions, there are company jurisdiction where digital technology has been going on for the last 9-10 years.
Yes.
So there, people may be able to handle those jurisdictions.
I personally like your 2 points where you said, okay, everything on digital should be open. It's not like a partial number of judges, only a select number. And second, you said every 3 days review. If we see there are no numbers coming, then why not open physical? Yes. These are good points. I think we are completely out of time. I would like to thank you, Mr. Mohit.
I wanted to add only bullet points. Should I give? I'll take less than 1 minute.
Okay.
See, there are many. What I feel is because of the backlog, etc., we need drastic judicial reforms. Some of the aspects which are discussed here, number of judges, appointments, etc. And when Mohit is saying that we should go whole hog VC, and on the other hand, he himself contradicted when he said that we can't go on digital mode because we don't have proper infrastructure. But the remedy for that is to create that infrastructure.
Yes.
Today, technology has proved that it was simply an automation. It can be now revolutionize the judicial system. And let us have that. And what I want to add is, in addition to that, that time has come where we have to use mediation techniques, ODR. ODR, when we talk of ODR, it is not online dispute resolution, virtual hearing here only, whether it is arbitration, whether it is mediation, whether it's small disputes, consumer disputes, etc., and small, and which are going to come after this, there's going to be a spate after this lockdown or after this COVID. Why not on ODR move online those things? So all these, the experiments are to be done. And we have to, like, it's a vicious circle where we have to break from every. And I would also say that as far as tribunals or some, like we have commercial courts, etc., in Delhi and others elsewhere, we need expert judges now who have the experience in these fields, and they should be put to do. Like now, for intellectual property division is created, that the law is passed, but we need the judges who know intellectual property law. So that has also to be kept in mind while making the appointment.
Point very well taken. Thank you so much, Mr. Parag Tripathi, Mr. Ryan Karanjawala, Mr. Vivek Tankha, Justice Arjun Kumar Sikri for making time and joining us. Very, very good inputs for today's show. Very good interventions. I hope and pray that our Chief Justice of the Delhi High Court and the Supreme Court takes note of these observations. The Delhi High Court is a court from which a lot of other high courts take cue from. I think even they will benefit from the decision that our Chief Justice at the Delhi High Court takes. Of course, Chief Justice of India, Justice N.V. Ramanna, has spoken about this whole body that is going to look into infrastructure of the courts. I think that will speed up Justice Chandrachud is having the purse strings as far as buying of equipment is concerned. I think there's some action we'll see in coming days, but that's for some other show. Thank you so much. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.